Welcome back to another edition of Between Two Fars. I am very excited to introduce a new series. We're going to be talking about the differences between litigating in front of the GAO and in front of the Court of Federal Claims. And we have got a wonderful guest speaker today. Brian Stanford has been with NASA since 2014, and he is currently a senior attorney advisor in the headquarters office of General Counsel, practicing procurement law. But prior to coming to NASA, he had about 5 years at government work as well as the private sector doing this type of litigation. So he is a treasure, a storehouse of knowledge on this issue, and is able to really speak to us about the subtle details that you might not understand if you suddenly find yourself in litigation in front of the Court of Federal Claims while you're used to really litigating in front of the GAO. So, Brian, let's talk about a couple of these differences. First off, big picture, why don't we start with jurisdiction? Can you tell us a little bit about the jurisdictional differences?
Absolutely. Thank you, Warner Keefe. First of all, let me just say thank you for having me on the program. I am a longtime fan of the show, and this is really the honor of a lifetime for me to be asked to come on and talk about
yes, our
these
huge
topics.
Viewership that we have.
Absolutely. No,
Tons
it's huge for me to be here. I appreciate you inviting me on the show. So yeah, jumping right into it. You're absolutely right. These are really critical differences because we're seeing, in the bid protest world, we're seeing litigants going, to the Court of Federal Claims after GAO more and more often, and also heading straight to the court and actually not going to the GAO. So I do think it's really important for practitioners with the agency who are litigating bid protests to be aware of these differences because they do matter. So on the first topic, jurisdiction, you're absolutely right. So GAO is jurisdictionally bound by CICA and GAO's own regulations for bid protests, but the GAO's jurisdiction is actually limited to any protest concerning alleged violations of procurement statutes, regulations by federal agencies in the award or proposed award of contracts for the procurement of goods and services and solicitations leading to such award. And so there's the jurisdiction in a nutshell. Obviously, the language is plain, but very the application is very squishy in terms of what's actually able to be heard by the GAO as a reviewing body. I think categorically the GAO, what we've seen, especially in the past 10 years of precedent, is very bullish on taking jurisdiction on an issue that arguably they may not have jurisdiction over. To round it out, their jurisdiction over protested task orders under IDIQ contracts is prescribed for civilian agencies. The $10 million value is the threshold, and for DoD, it's the $25 million threshold. So that's the value of the task order that is contested. And then for the Court of Federal Claims, their jurisdiction is governed by the Tucker Act, which gives the court, which is an Article I court, broad jurisdiction over any protest in connection with a procurement or a proposed procurement. So a ton of case law out there about what does in connection with really mean. Generally, there's the court's barred by statute from hearing protests in connection with the issuance of task orders under FAR Part 16. So that's kind of the jurisdictional parallel there for those reviewing bodies.
Yeah, I understand there's also some differences in the decision maker. If you find yourself in front of the GAO, who's going to be deciding the case, and what happens when you show up at COFC?
Yeah, absolutely. The GAO, the decision maker in that case is we call them different things. Typically, it's senior attorney, senior procurement law attorney, often informally referred to as a hearing examiner as well, kind of an administrative law judge. These are attorneys that are highly specialized in the area of federal procurement law. This is what they do day in and day out, and they hear and adjudicate potentially hundreds of protests a year, each one, versus the Court of Federal Claims, which is again an Article I court that is staffed with federal judges who are nominated by the president, confirmed by the Senate through the confirmation process, and they have a term of 15 years. And so we've seen a lot of turnover actually in the past few years on the Court of Federal Claims judicial membership. But recall that the Court of Federal Claims has jurisdiction here, other types of issues, not just bid protest litigation. And so, we see a lot of variation in Court of Federal Claims judges in terms of their breadth and depth of experience in contract formation law and bid protests. And a bid protest is potentially just one of many cases that a Court of Federal Claims judge may be hearing on any given day. They also have jurisdiction over contract claims and disputes as well. So.
Wow. So kind of maybe a roll of the dice as to how much of an expert you're going to get if you end up in the Court of Federal Claims.
Certainly, certainly.
Well, what about the attorney side of it? Who's going to defend the government in these two forums?
Yeah, this is a huge difference for us because as agency practitioners, right? Because at GAO, any GAO protest that's brought by a protester will typically be the legal role will be taken on first chair by the agency attorney or attorneys, from the agency. However, when you go to the Court of Federal Claims, the kind of first chair responsibilities for litigating the case are turned over to the U.S. Department of Justice, particularly their National Courts Commercial Litigation Branch. They basically have a team of attorneys there that work on government contracts issues, including bid protests. So when assigned by the Department of Justice, NASA or any other agency will receive at least one usually one Department of Justice attorney to kind of take on the primary litigating responsibility for the case. However, agency counsel is heavily involved with helping to defend the case with the Department of Justice, and we can talk about more about the particulars of that relationship in another episode.
Yeah, I think that would be terrific because that's actually applicable to a number of different interfaces that we have with DOJ. This has been fascinating. I think really lays the groundwork for some of those differences between litigating in front of the GAO and COFC. Would you mind coming back for another episode and talking to us a little bit more about some of those other differences?
Absolutely, would be happy to.
Fantastic. You stay with us and we'll see you back here on the next edition of Between Two FARs.